Allow me to welcome you to the first lecture of the spring quarter at the Wood Institute. It gives me really great pleasure to initiate our spring lectures with the contribution of my esteemed colleague, Dr. Hilma Klinkott, Professor of Ancient History and the History of the Near East at the Institute of Classical Studies at the University of Kiel, and presently a Getty Scholar at the Villa. As usual, I would like to seize this moment at the outset to thank our colleagues at the Getty for graciously facilitating these academic exchanges between the Getty Scholars Program and the Wood Institute. Professor Hauser's work, which focuses on the relations between the Mediterranean and the ancient Near East, in particular the Achaemenid Empire, is distinguished by its great capaciousness. His publications reflect his wide-ranging research interests. His first book, the Satrapienregister der Alexander- und Diadochenzeit, published with Schane Verlag in 2000, treats the thorny issue of satrapal registries on the Alexander of Macedon and the successor states. An important contribution to the field of Achaemenid studies has been his monograph, Der Satrap, ein achämenidischer Amtsträger und seine Handlungsspielräume, published in 2002, which builds upon the strength of his doctoral dissertation. The work represents the first attempt extensively to reify the important institution of the satrapy and his office holder, whose expansive and variegated powers and activities determined Achaemenid policies in Asia Minor, the Levant, and Egypt. Needless to say, this excellent tome continues to serve as a standard work in the field. His good taste in picking important subjects to which few have paid heed hitherto in a fitting manner is once more manifest in his latest publication, which I have particularly enjoyed reading, namely Xerxes the Großkönig in Griechenland. That came out with Kohlhammer this just past year in 2023. In truth, this is a monograph on the much maligned and vilified great king Xerxes, who has been the subject, has been subject to bad press like no other in antiquity, of course, on account of his campaign against the mainland Greece. It is furthermore a subtle treatment of diverging perceptions and expectations from the perspective of the Persian Empire and the Greek polis, and the rationale behind the Persian Wars, about which we shall also hear from our colleague Robert Wallinger next week already. So the two of them complement each other very nicely, these two lectures. His lecture today, however, is solidly situated within the larger framework of interdisciplinary approaches and espouses many aspects that have hitherto characterized his scholarship. It represents a fresh attempt at defining the royal Achaemenid inscriptions beyond our discernment of them as a discursive construct, aiming mainly to project the imperial project afar, but instead defining them as inherently capable of expressing legal concepts with all the ramifications that such a proposition entails, namely the possibility of them being binding upon projection. So it is with much anticipation that I would like to give the floor to Professor Hilma Klinkott for a lecture entitled, it's a long title, please forgive me if I do miss some of them, Consolidation of Law, Legal Order, and the Question of Constitutionalizing Processes in the Achaemenid Empire. Thank you so much. Please. Thank you so much. Thank you.
Thank you very much, Rahim, for this very kind introduction. And of course, I have to thank first for this invitation here to the UCLA. It's really a great pleasure and a privilege for me to be here and to get the chance to present some of my actual research topics. But I also have to confess that the topic I will talk about today is not really new. 2 years ago, on a conference of the Getty Museum held at the UCLA, I just presented the tomb of the inscription of Darius I at Naqsh-i Rustam, the Naqsh-i Rustam B text, its legal elements, and the question for its function as Achaemenid legal order In the following discussion, I got very much helpful input by Sarah Morris. Her critical questions and arguments stimulated me to rethink and to re-question the terms of legal order and constitution and in its relationship to one another. Against this background, I would like to ask once more explicitly for the law consolidating character of these Naqsh-i Rustam inscriptions, its supposed quality as a definition of legal order, and its character as an explicitly constitutionalizing text. Just as a short preliminary remark at the very beginning, please keep in mind that I'm absolutely aware of the problems connected with the terms constitution, constitutional, or constitutional debate, and constitutionalizing in the antiquity, and for using it also for situations in the ancient Near East. I know that they are closely connected with the democratic legal order of the ancient Greek polis. I know that the Greek, in particular the Athenian polis society, is the background of the constitutional discourses in philosophical and historiographic literature. But to turn the view from this Greco-centered perspective in the specific Greek context and to open the mind for new approaches, we first of all have to clarify two basic questions. And I'm not really sure if I'm the right one to answer that, but we have to put that. First of all, is a constitution or is constitutional thinking exclusively connected with the ancient Greek polis world, or are constitutionalizing processes also conceivable in other non-Greek polities? And secondly, what is a constitution? Concerning the first question, the modern history can easily help with the answer. Of course, a constitution and even democratic constitutions are not only linked to the ancient Greek polis. In modern history, we find them in other times and in other polities all over the world. Not even their legal order has to be exclusively democratic. In principle, monarchies too can be based on a constitution, forming the so-called modern constitutional monarchy. You all know that. This aspect in mind can open the view to the principal possibility that constitutions or constitutionalizing processes were not a specific characteristic of the ancient Greek world, only connected to the polis or a particular democratic order. Secondly, to the definition of a constitution. In modern understanding, a constitution is the legal basic order of a corporation, not necessarily named citizens, forming a polity. In this definition of Gerhard Köbler, I'm sorry just to have it in German, the definition of Gerhard Köbler clearly mentions as core aspects, first of all, the constituent corporation, in modern terms forming the state. Secondly, its legal function as basic order, and thirdly, its absolute validity in respect to time, political conditions, or different groups in the polity. According to another author, Hermann Avenarius, writing in a handbook for law studies in Germany, a constitution is the superior law usually fixed in a constitutional document which regulates the organization of a state and the individual right of its legal subjects. In German, we would say the Rechtsunterworfenen, in absolute validity. In contrary to modern multi-ethnic states, we cannot take the institution or the understanding of something like an imperial citizenship in the Achaemenid Empire for granted. But the Achaemenid inscriptions clearly point out that the legal subjects are the inhabitants of the empire, called Kshatra, as something like a state territory. For special cases, as for example catastrophes, wars, pandemic, crisis, etc., etc., a constitution can pin down regulations for an emergency legislation. Therefore, it can, but need not obligatorily be fixed in a written text with a superior legal quality. This in view, a constitution has not only an absolute but also a general character. Also, it is not an intrinsic aspect. In modern understanding, a constitution means the literary fixed, legally binding text of this basic order. So, for example, also Heinz Mohnhaupt and Dieter Grimm give as definition constitution. Is this right? No, I take it the next one here. At the base, constitution means today the literary fixed, legally binding structure of legal norms superordinated to the ordinary law for the organized state polity. In consequence, when a constitution is realized by textual fixation, its legal quality has to be designed by an official, legitimate, sometimes political institution, which need not necessarily be elected by citizens. Therefore, the legitimacy and the authority of its authorship is a crucial fact and has to be proved in the text. It is questionable if this text must be self-contained as a consistently designed written document. If so, the United Kingdom of Great Britain and Northern Ireland, with its combination of constitutional laws as the Magna Carta, common law, state law, and judgments, or Israel with its collection of the so-called basic laws, would not have constitutions. Furthermore, a constitution has to be phrased in a kind of general and principal abstraction for universal validity. The legitimization of a constitution happens by an act of installation, designed and performed by an authorized and legitimate institution, and by its practical working in interrelation between the legitimacy of the state sovereignty and the acceptance of the legal subjects. In consequence, a constitution is not bound on a special time, pre-modern or modern, and a special region. It is not bound on specific form of political order, city-state or federation, polis or koinon, on a specific form of political system, democratic, monarchic or oligarchic, and even not necessarily on a particular nationality or on a nation-related state territory. We have to talk about this a little bit later. Even though the textual fixation is not mandatory. Although there are basic elements of definition, the term constitution owns a kind of flexibility in its application. This in mind, we are allowed to ask for constitutions and constitutionalizing processes in the ancient Near East beyond the Greek polis context and beyond the regulation of just being a legal order. Many scholars as Fritz Knitzer, Helene Sanchisi-Werdenburg, Jan Assmann and Josef Wiesehöfer have shown that constitutional thinking in antiquity is not restricted to specific philosophical discourses in the ancient Greek polis. Against this background, let us return to the inscriptions Naqsh-i Rustam A and B, the both inscriptions at the tomb of Darius. Viewed to that text, we are faced with the following questions. What says the text and what are its legal terms? Why are these both inscriptions not only a royal representation drawing the picture of an ideal ruler? Which elements of the text create, so to say, a law consolidating quality? And is this text a political manifest, a legal order, or even a constitutionalizing document? The famous tomb inscription of Darius is known by the two texts numbered DNA, Darius Naqsh-i Rustam A and Naqsh-i Rustam B, both interacting with each other by textual relations and by their common material context. Obviously, the Naqsh-i Rustam A text is only the first part of the whole script containing the full royal title and legitimization, the definition of the empire, the list of peoples, the Dahirwa list, and the illustration of the great king as legislative and executive authority. He installed the law, restored the right order, and guaranteed its stability. The second part, the Naqsh-i Rustam B text, is the only Achaemenid text which deals with the personal data on the physical and intellectual qualities of the great king. Usually, its supposedly biographic character seems to draw the deceased king in the picture of an ideal, perfect ruler. With respect to the tradition of Egyptian epitaphs, the tomb inscription of Darius might perhaps be composed on a first view as an, so to say, ideal biographic text. On the other side, the presentation of royal qualities in Naqsh-i Rustam seems to offer eternal and programmatic messages, as Josef Wiesehöfer calls it, or with other words, a manifest of the political order under the rule of the Achaemenid great kings. However, beyond its importance of religious legitimization and royal ideology, the text can also be read with a legal approach. As I said 2 years ago, I presented these legal elements and terms here in detail. Therefore, I think it is quite boring to repeat it in all these details. Instead, I would like to focus on 2 other aspects and bring into discussion. But first of all, I have a short introduction into the contextual and legal elements. In Naqsh-i Rustam B, paragraph 1, I have it, a short introduction. You have this also on the handout, so you don't have to read it on the slide. In Naqsh-i Rustam B, paragraph 1, a short introduction or preamble headlines the main overall subject of the text. It deals with the wisdom, as Rüdiger Schmidt translates it, or discernment according to Wiesehöfer, and the ability bestowed upon Darius by the god Aramazda. The following text is then structured into 2 main parts, A and B. The first part, the A part from paragraph 2 to 6, deals with the first quality, wisdom and discernment as intellectual distinction. Part B from paragraph 7 to 10 focus on the ability of the king as practical use and consequence of the intellectual qualities. At the end, the text closes with paragraph 11 and 12 as an address to further rulers, repeating some of the core statements. The first part A dwells on 5 aspects, particularly shaping the royal quality of wisdom, while the second part B on the royal physical ability is explained by further 4 aspects. Especially the first part is marked by a lot of legal features which confirm and define the royal legitimization by law and justice, particularly in paragraph 2, following the traditional Mesopotamian topic of the so-called king of justice. The main aspect in paragraph 2 is the rightly balanced judgment. Accordingly, the great king is the only authority which guarantees to prevent injustice against both parts, the strong and the weak ones. In juridical terms, Naqsh-i Rustam B explains a general principle of appreciation of values which determines the adequacy of reasonableness. The principle is fundamental for the later paragraph 5, which focuses on the balance of judgment. Paragraph 2 is unique in its regulation of principal tolerance, considerateness, and protection. With this in mind, the regulation of audiatur et altera pars in paragraph 5 can also apply to the protection of minorities mentioned in paragraph 2. The latter has not only individuals or several groups of persons in mind, but also peoples and countries, as the Susa inscription E, paragraph 5, makes clear. In addition, the protection of a minority is not allowed to dictate the interests of a majority or of the political powerful, that means the responsible one. Furthermore, the text reflects for the first time the concept of a superior legal understanding, which also affects to the position of the great king. At the same time, he is the warrantor of this legal balanced order because being the authority institutionalized and legitimized by the god, and thus the great kings were obliged to it. The following paragraph 3 touches a new aspect which essentially characterizes the royal responsibility to guarantee balanced. The following paragraph 3 touches a new aspect which essentially characterizes the royal responsibility to guarantee a balanced right judgment. Intensified in its meaning by the wording of a negative confession, the king explains in paragraph 3 the physical self-control and self-restraint of his emotions. Thus, the text relates to the juridical category defining rationality as an appropriate method and competence for verifying and applying the mentioned reasonableness. It imposes as a principle of conduct on the great king to control his effects in acting and decision-making. Together with the protection of minorities and the audiatur et altera pars principle, it means at the end a constraint on royal behavior. The great king is not allowed to rule in an, so to say, absolutistic way and to act like a despotic tyrant, as the Greek sources like to describe it, following his spontaneous and unreflected effects. So the next paragraph 4 on care and punishment starts in this first part to explain the abstract ideal which follows the practical realization by the king's action. According to the principle of reasonableness explained in paragraph 2, the first part of Naqsh-i Rustam B paragraph 4 deals now with the adequacy of the method. The second part relates to the necessity of the right method in a legal category concerning the verification of reasonableness. The main topic of the paragraph is a discussion on the punitive purpose. In German we would say Strafzweck. Justice is to punish wrongdoing. Obviously, the maxim is a general principle of the Achaemenid monarchy, as the Byzantine inscription in paragraph 64 clearly says. Beyond the clear position of the king against wrongdoing, this part reflects an absolute concept of justice in which wrongdoing is not allowed to be unpunished. It needs the great king as legal authority and chief justice with his duty to guarantee the legal order and thus stabilizes the empire. Also, this idea is already introduced by the Byzantine inscription in paragraph 55. Paragraph 5 of the Naqsh-i Rustam B inscription relates to the question how to handle the balance of judgment in practice. Thereby, the paragraph takes up the principle of reasonableness by putting paragraph 2 in concrete terms and then defines the royal principle of criminal procedure. For my understanding, paragraph 5 is the earliest source which mentions this legal principle of audiatur et altera pars, mainly known from the much later Roman law. Certainly, it is one of the most important aspects in this inscription because it is repeated once more in paragraph 11. The enumeration of legal basic principles is completed by paragraph 6 on merit and wages as positive perspective for loyal followers, and certainly referring to paragraph 4. This statement formulates under a legal perspective the right behavior expected by the great king, otherwise accepting the corresponding service of the loyal man. The appropriate correctness is confirmed by the satisfaction of the great king. That means these lines deal with compliance and effect of right actions. They ensure a royal confirmation as a reciprocal gift in return, as demonstrated also in the Byzantine inscription, paragraph 68 and 69. At the end, the loyal followers, men, groups, and countries enjoy privileged rights. They have a claim to royal wages for their merits, as Naqsh-i Rustam B paragraph 6 clearly states. The second part of the B inscription, paragraph 7 to 10, deals with the ability, in addition and consequence of the qualities just described in the first part, as Naqsh-i Rustam B clearly points out. It says, that is my ability in addition to thinking and intelligence. Therefore, paragraph 8, with a clear reference to physical conditions, my ability that my body is strong, describes the king as a good battle fighter because of the combination with his intellectual qualities. So he is able to defeat the panic as a proof or a sign of the only legitimate king, as Julian Degen demonstrated in the context of Mesopotamian traditions. In consequence, the great king is victorious against any rebel or enemy, the destroyers of the right legal order. Naqsh-i Rustam B paragraph 9 substantiates this, describing the king as good horseman, good bowmen, and good spearmen because of being fervent in counterattack. This ability of counterattack is important because it protects, defends, and stabilizes the legal order, thereby implying a reference to the legal context of the first part. So paragraph 10 clarifies the enforcement and the right use of the God-given qualities, determining the realization of the legal implications of paragraph 7 to 9. Finally, the last paragraphs, 11 and 12, address directly to the reader, once more highlighting some of the most basic principles mentioned in the part A. View to the interrelation of the great king to his followers, the general intended feedback effect of the legitimized king to his peoples, maybe as a kind of royal accountability, is highly remarkable because it affects vice versa the legitimization of the great king as mentioned in the Bizitun inscription paragraph 60 and 61. Indeed, this institutionalized authority is restricted by several rights the legal subjects have in respect of the great king. The legal principles guarantee the protection of their local peculiarities, not because of the king's personal willing, but because of his law. It demands from the great king to protect, so to say, the weaker, as for example, powerless groups or minorities, to respect their interests even against another, so to say, stronger, that is more powerful or major or somewhat side, and thus to judge in every single case according to the specific local conditions, as the Naqsh-i Rustam text emphasizes in iteration at the very end and in paragraph 12. The legally restricted position of the great king is a crucial aspect and also given by further regulations. So, for example, the Bizitun text clearly points out the duty of the great king to inform the people about his policy in a kind of transparent way. So, Bizitun paragraph 60 and 61 might be interpreted as a kind of accountability, in particular view to its violation exemplified by Cambyses in the same inscription in the paragraph 10 and 11. It says, because the king Cambyses evades the disclosure of killing Smerdis, the people, the Kara, became disloyal. This affected a situation which made Gaumata's coup possible because of false statements that he was able to seize kingship illegally. Furthermore, the uprisings and the following circumstances are shaped by the dissolution of the legal order and the lack of an institutionalized legal authority, as Bizitun paragraph 13 says. In contrary, the right behavior of a king, that is, the realization of its accountability to the people, is demonstrated by the great king's announcement in his empire, as Bizitun paragraph 70 explains. This statement is much more than only illustrative. It simultaneously documents the literary fixation, indicates the authorship of the text by the legally institutionalized authority, proves the publication of the legal basic order, and confirms the legally correct performance of the consolidating regulations. The great king is the political and legal representative of the right way, the Pathim Rastam, and thus the superior legislative, executive, and juridical authority legitimized by the God our Master. Maybe this legal background is the reason why the great king used to emphasize in the royal inscriptions their quality as Framatara, the one who sets the right order in addition to their position as great king. The king knows the right place of each country in his empire and is the only one to put countries or peoples on it. That means to reinstall the right order. Therefore, the instructions of the great king are royal law, data, and expressions of practiced legal order set by the God our Master, our Master. In fact, this practice of consolidation is also able to shape a constitutionalizing process and corresponds with Sabine Müller-Malls' term of the so-called constitutionalizing judgments, die verfassenden Urteile. We have to speak about that a little bit later. The use of legal principles, which Naqsh-i Rustam B formulates in an abstract, universal manner, shows that the specific regulations are always placed in and related to a political imperial context. This, in view, the inscriptions Naqsh-i Rustam A and B are much more than a political program or a guideline for a future ideal great king. It is the programmatic definition of a legal order fixing the legal principles of government guaranteed by the institutionalized authority of the vice versa legitimized great king. Nevertheless, there is good reason to wonder if the tomb inscription of Darius is only text for royal representation, just illustrating the king's power and competences and drawing the picture of an ideal ruler. Therefore, we have to determine the momentum where the ideal biographic self-presentation of the deceased king turns into the quality of a law-consolidating act. Indeed, the point of reference is a core aspect for it. Who are the addressees and participants of this legal order as its legal subjects? The function of legal consolidation is given by the reference to the subjects in the empire. The royal regulations, so to say the legal order described in Naqsh-i Rustam B, clearly relates to the peoples of the empire by stylistic, linguistic, and textual references interconnecting Naqsh-i Rustam A and B. Both inscriptions at the tomb have to be understood as one consistently composed text. Remarkably, Naqsh-i Rustam A is the text which clarifies the essential requirements for constitutionalizing quality. As mentioned at the beginning, a constitution in modern understanding is the basic order of a state, die Grundordnung eines Staates, we would say in Germany, defined by the sovereignty of the state and the state monopoly. This state sovereignty is usually defined by A, the constitutive people, B, possibly the state territory or its legal area, and C, the state power or the state authority. Due to the Naqsh-i Rustam inscriptions, all these aspects can be identified. In A, the peoples as legal subjects mentioned in the so-called Dahirwa list, the lists of the people. B, the explicit mention of the Kshatra as state territory or imperial legal area. And C, by clearly defining the great king as institutionalized state authority, legitimized in Naqsh-i Rustam E, religiously by the god Mazda, dynastically by the list of family predecessors, and territorially by the possession of the empire, the Kshatra. So, the first paragraph of Naqsh-i Rustam A could be understood as an indication which defines the constituent institutions, the god and the great king, as authorities and authors of the following regulations. At the end, a constitution works in practical use between human beings by its legitimacy and its acceptance. Both aspects are documented in Naqsh-i Rustam A. At the beginning, Darius clearly points out that he as the ruling great king was the institutionalized authority. So Naqsh-i Rustam A, paragraph 3 says, proclaims Darius the king by the favor of our master. This is legitimization. These are the countries which I seized outside Persia. I ruled them. Correspondingly, the acceptance is immediately stated in this particular context when paragraph 3 goes on, to me they brought tribute, bayim, what has been said to them by me that they did. In fact, these two sentences illustrate both perspectives of a working acceptance. Bottom up, the formal acknowledgement of the peoples of the empire by the act of bringing Baji, rather interpreted as the part which the great king was entitled than as a tribute or gift. And then, top down, the legitimated application by the instruction of the authorized institution, that means the great king, and its appropriate implementation. So Naqsh-i Rustam B directly relates in the very first sentence and the first two lines to this definition of rule and empire in Naqsh-i Rustam A when it says, a great God is our master, who created this marvelous. Maybe there is another peculiarity which has to be pointed out if the Darius tomb inscription will or might be read as a constitutionalizing text. As mentioned above, a constitution in modern understanding can also regulate its validity and handling in special situations, as for example in catastrophes, wars, by an emergency legislation. Only in Naqsh-i Rustam B, paragraph 7, the basic qualities defining the Achaemenid kingship are aggregated and focused on their equal validity under different conditions. The usual situation of ruling at the court, that means at home, in the peace, I don't know, as well as the special case of ruling in warfare, in the battle. A remarkable common element of both inscriptions is that they address, in Naqsh-i Rustam A, paragraph 6, and Naqsh-i Rustam B, paragraph 11 and 12, to the future ruler, the future Achaemenid great kings, as successors of Darius in an entirely general way. Of course, we know this literary practice from the Byzantine inscription, which also addresses directly to the reader and succeeding kings in the paragraphs 60, 61, 64, 67, and 69. Comparable with the famous Thermopylae epigram attributed to Simonides of Chios, proclaimed to the Spartan stranger that, and so on and so on. The tomb inscription of Darius II has the character of an, so to say, epidactic and epitimbric epigram. One might say that the Byzantine inscription of Darius II has a pseudo-epigrammatic character when it tells at the beginning of nearly each paragraph proclaims Darius the king. But why does not the Naqsh-i Rustam inscription use this particular phrase? Or, to be a bit more concrete, where is the difference between the stereotypic phrase of the Byzantine inscription and the address of the Naqsh-i Rustam text? First of all, the Byzantine phrase has to be told a proclamation, while the Naqsh-i Rustam text is a direct speech immediately addressing to the future reader by an exclamation. While the Byzantine phrase states the proclamation of the king, Naqsh-i Rustam B, paragraph 11 and 12, build up a direct interaction between the text and his audience, the reader of the text. The difference between the proclamation phrase of Byzantine and the direct speech of Naqsh-i Rustam A and B is much more than only a stylistic variation. It has a special function and effect for the whole text, in my opinion. Its character of an epigrammatic speech turned the ideal presentation of the qualities of the deceased great king into a general law consolidating program. This progress seems to be explained on behalf of John Austin's speech act theory. Therefore, John Austin states, quotation, "The uttering of the sentence is or is a part of the doing action, which again would not normally be described as or just saying something." Austin shows that the action by saying performs a change of conditions by the example of marriage. When I say before the registrar or the altar and so on, I'm not reporting on marriage, I'm indulging in it. He clearly defines the speech act as a case, quotation, in which by saying or in saying something, we are doing something. Furthermore, the marriage example clearly demonstrates that the speech act is able to constitute a new legal status to legalize a specific fact. This kind of sentences carrying out a speech act are usually characterized, as he says, by hand-drawn verbs in the first person singular present indicative active. Austin proposes to call them performative sentences or a performative utterance, or for short, a performative. The supposedly biographic first-person singular in the Naqsh-i Rustam B text seems perfectly comply with it. To be more concrete, the speech addressed to the reader at the end of Naqsh-i Rustam B in paragraph 11 and 12 is, in the sense of Austin, explicit performative. It is remarkable that not only Naqsh-i Rustam B but also Naqsh-i Rustam A ends with such an explicit performative speech act. These epigrammatic speeches address to a more general audience not only the future young man, the Marika in paragraph 11 of Naqsh-i Rustam B, but every man, as Naqsh-i Rustam R in paragraph 6 says by the word martia. Obviously, this term martia is used in the general meaning of mankind, as clearly introduced at the beginning of the particular inscription in paragraph 1 in relation to this same divine authority. Furthermore, paragraph 6 refers on our master as a transcendental, superior legalizing institution, clearly defines the illustrated content as the right path. I marked it here, not only in religious, Zoroastrian, but also in a legal sense, and finally postulates the common obedience to this legal way or legal order. Maybe the serious legal quality of the text is the reason that its pseudo-epigrammatic character and the speech act in particular are not composed in meter. So Austin states, a performative utterance will, for example, be in a peculiar way, hollow or void, if said by an actor on the stage or if introduced in a poem or spoken in soliloquy. It is the authority of the, so to say, right actor and the right proper situation which create the legally effective quality of the action and even the performative sentence of the speech. According to the speech act theory, the utterance is not only an action, it creates a new factual status. Even in Austin's explanations, this process is intrinsically connected with a change of legal quality. The speaker's authority, the formal right wording, and the right situational setting create the legitimacy and effectiveness of the new legal status. This law consolidating quality is the exact proper meaning of the Latin edictum. In its proper sense, a loyal law became valid in its legal dimension pronounced by the legitimate authority. This process is also already known from the Egyptian literature. So the instructions addressed to Meri-Kare, king of the 10th dynasty in the first intermediate period say, "Do not neglect my speech, which lays down all the laws of kingship, which instructs you that you may rule the land." But what does that mean for the Darius inscription at Naqsh-i Rustam? First of all, the great King Darius, as legalized authority, is essential for the effective performative quality of the speech act and the whole epigraphic text. Only his status as great king, given by the royal legitimization demonstrated by Naqsh-i Rustam A, as well as by the qualities Darius attested to have been in possession, implies the capacity to perform the law consolidating quality of the text. The crucial turn from an ideal royal self-presentation to a law consolidating text is given in particular and in a singular way by these speech acts of the inscription. When we read this text with the speech act theory in mind, the biography aspects turn into elements expressing the consolidating act of a new legal status, especially the use of the first person singular present indicates active is a central marker for this. For these first person present verbs, as Austin says, actions can only be performed by persons, and obviously in our cases the utterer must be the performer. End of quotation. The reason is, once more, the intrinsic act. Another quotation of Austin, there is something which is at the moment of uttering being done by the person uttering. End of quotation. However, by verbal utterance, the utterance origin is evident, as he says, by his being the person who does the uttering. End of quotation. But in written utterances, Austin calls it inscriptions, the authenticity and performance of the action have to be confirmed, as he says, by his appending his signature. The indication and attestation of the author is crucial in this case. So he says, this has to be done because, of course, written utterances are not tethered to the origin in the way spoken ones are. In the case of Darius Naqsh-i Rustam inscriptions, the use of the direct speech in the first person singular performs the consolidation act. The authorizing signature, which is necessary for it, is obviously given by the whole context of the tomb of the deceased great king Darius. The particular place of the inscription at the front of the tomb monument, the associated illustration of the tomb relief, and the introducing phrase of Naqsh-i Rustam A, the Naqsh-i Rustam A inscription, clearly sign the utterance origin. The inscription is not only placed directly on the left side behind the king's figure, it directly addresses the reader to watch the relief. Furthermore, the tomb of Darius is one of the very few examples defining the figures of the illustrated peoples by additional inscriptions, once more strengthening the interrelation of the pictorial and epigraphic representations. Maybe this so-called iconotextuality let the illustrations perform a so-called image act, a build act as studied by Dirk Westerkamp, but this is another topic and field of research I don't want to talk this evening. Due to the importance of the text, it is comprehensible that the tomb of Darius is the only Achaemenid rock cut tomb which can be identified for certain by this inscription and which owns such a biographic tomb inscription at all. Against this background, now I will use at the end the opportunity to throw the heretical question into discussion. Could Naqsh-i Rustam be understood as a constitutionalizing text? If we remember and double-check the core aspects of a definition, we have to realize consistent literary fiction is given by the epigraphic character of Naqsh-i Rustam A and B. Its permanent effectiveness in publication is also given by the fact of being a stone inscription reproduced several times in the context of the residences. Its design by an official legitimate institution is given by the indication of the great king's position and his legitimacy by the god our master, especially in Naqsh-i Rustam A. Its absolute validity is given by the formulation of general legal principles equally valid in peace, at home, at the court, and in war, explained in Naqsh-i Rustam B. Furthermore, a general validity for the entire polity is given by the underlining of royal laws, the data for all peoples, the dahiyawa in the entire empire, the shacha. The universal abstraction of a comprehensive basic order is given by the general wording of the legal principles in Naqsh-i Rustam B and, of course, of its historical, so to say, unconcreteness. The definition of a state territory in, so to say, state territory is given by the term shacha and its definition by the people of the empire in Naqsh-i Rustam A. The state power of authority is given by the legitimacy of the great king, its formal institution, and the definition of his position. The constituent state people or the state corporation is defined by the peoples of the empire, listed in Naqsh-i Rustam A as legal subjects. The proof of authorship is extensively given by the identifying elements of the tomb inscription, the tomb itself, and its pictorial program. The top-down working of the legal order by the political institutions is given by the illustration of royal laws guaranteeing stability in all countries of the empire and proving the legitimacy of the so-called state sovereignty even by the god. And finally, the bottom-up acceptance by the legal subjects is given in Naqsh-i Rustam A by the peoples obeying the royal law and bringing Baji as act of respect or acceptance towards the royal institution. additional, it might be interesting to bring these characteristic elements of the inscriptions and their imperial contextualization together with the recent theory of Sabine Müller-Mall, professor for legal and constitutional theory at the Technische Universität Dresden. Indeed, she studies modern constitutional development in a completely other modern transnational context. But, in particular, the multi-ethnic structure of the Achaemenid Empire might offer comparable conditions in which the constitutionalizing quality of Naqsh-i Rustam, the Naqsh-i Rustam inscriptions could be understood in the sense of her concept of the so-called verfassenden Urteile, the constitutional judgments. The new aspect of Müller-Mall is stimulated by the fact that that the expansion of polities beyond the scope of nationally defined states in multi-state entities, as for example the European Union, develop comprehensive constitutions not only by a single constituting act, but also by the process of consolidating laws and legal order. She clearly emphasizes, viewed to large political, non-nationally defined units, as for example the European Union, the meaning of the so-called entgrenzte Verfassung, perhaps to translate as untrammeled constitution. In this understanding, she explicitly defines, and this is a very hard quotation, I am sorry for that, this means that political rule is not only exercised subjectively, but becomes the object of a taming that we call the limitation of rule. If this link between the exercise of rule and the limitation of rule is structured in such a way that whoever rules subjectively is objectively limited in his rule by the one who is objectively ruled, and at the same time subjectively limits the rule, that means for our inscriptions, for example, the royal restrictions discussed above, that means if rule can be described as a reciprocal relationship of subjugation, then we speak of a constitution, and this enables the idea of constituent legitimization. And against this definition, the parts restricting the behavior of the great king in these inscriptions are of major importance. This form of constitutionalizing process need not exclusively democratic, as she too clearly states in this context. By the combination of Sabine Müller-Mall's concept of constitutions in transnational entities, developed, shaped, and established by the legal use and practice of judgments, and John Austin's Speech Act theory, we might reconsider the possibility to understand the tomb inscription not only as a law consolidating, but also specific constitutionalizing text. This is what Josef Wiesehöfer unwillingly described for Naqsh-i Rustam B, although without to risk naming by the unconstitutional term. He says the great king does not just publish decrees, does not just give orders and commands. Instead, he provides his subjects with an integral, well-intentioned, well-articulated, well-balanced, and well-founded, and now he says, system of behavior patterns that meet our master's expectations, that help to impose and guarantee law and justice to the favor of all, and that in the end provide, in the words of Xerxes, for the fact that he who obeys that law and worships our master becomes both blissful while living and blessed when dead. I thank you for your attention.